Good morning or good afternoon, everyone, depending on where you are in Australia. I am your host. My name is Joel Comerford. I'm one of the consultants over here at Lawpath, and as I mentioned, I will be your host moving forward. So, yes, welcome everyone, and thank you for joining today's session. Understanding business contracts and key legal terms every entrepreneur should know. If you've attended our webinars before or used Lawpath's legal marketplace, then you already know Damin Murdock, our highly rated senior lawyer. And for those who are new to Lawpath, we are very privileged to have him leading today's session. Now, with decades of legal experience and a reputation for managing high-profile business cases, Damon is a trusted expert in commercial, employment, and startup law. He holds a five-star rating from over 300 client reviews on our Meet the Lawyers page, where our top legal minds assist clients through our legal advice plan every day. With that being said, having that information about Damon, please, we really encourage everyone to ask as many questions as possible. We will obviously be focusing on specific parts of this webinar, but you can ask Damon other legal related topics, and hopefully he should be able to assist you where you need it. But yes, guys, please, we have a Q&A section, which we will address later on, and then we also have a chat box. So if anything pops up throughout the webinar, you can go ahead and drop it in there. It will be addressed by myself or Damon throughout. And as I was mentioning, yes, we do have a Q&A at the end, so you can stay tuned for that. If there's any really burning questions that you want to get answered, whether it's related to the webinar or to your business, whatever it may be, we will go ahead and make sure that we can respond to those. Now, today's session. Today, Damon will be focusing on the legal requirements for valid contracts, different types of business contracts for employment and lease agreements to service contracts, tips for negotiating terms and clauses, how to avoid common pitfalls in the contract signing process, the rise of e-signatures and their legal standing, and finally, how Lawpath can support your contract needs through smart legal tools and expert advice. Now, before we jump in, guys, for those of you who are new, a little brief on Lawpath. We've been around for 10 years. We've served over 500,000 businesses, which we take as a point of pride. Originally it was legal advice, and then we've evolved into everything else. We've got accounting, we do tax, we help people register businesses, whether it's sole trader, business partner, or company. We can help you with trademarking. We can assist you with getting a business name set up, or if it's something as trivial as just general advice on legal or accounting, we've got it all sorted. So with our plans, which I will go into more detail later, we offer unlimited 30-minute consultations with a senior lawyer for 12 months. So that means you get to have a call with a lawyer whenever you wish. Anything related to your business, if you need to create a will, if you're selling a business, if you need to change your share structure, if you're creating a company or if you're a sole trader and you just have no idea what you need to do or how to survive, you want to build those strong legal foundations, we can assist you with that plan. Adjacent to that, we have our accounting plan, which is almost identical in its features, unlimited 30-minute consultations with the senior chartered accountant. They would teach you how to do all of your bookkeeping, payroll, invoicing. If you want to invest in things in the future and you want to get a good idea of how to structure your business, where to save money, how to reduce taxes, things like that, we can help you with that plan as well. Or if you just want someone to just go ahead and do all your tax and BAS for you and you don't want to get too hands-on, then we have our tax plan as well, which is super helpful. More of that later on. So for now, we will just go ahead and pass it on over to Damon. Thank you so much.
Perfect. Thank you very much. Welcome, everybody. Welcome back from the long holiday. We're going to jump straight into it. We're just going to look at contracts generally. So I'll just roll with that. Again, if you have any questions, whether it's in relation to contracts or anything at all, I'm happy to try to answer it. Just drop it in the Q&A. So when we look at a contract, first things first, a contract is an offer, an acceptance, a meeting of the minds, and consideration. And that sounds like it's fairly simple. So a contract has four elements, and in law, we always use these elements. And so you have to prove that if you are going to sue on a contract, for instance, you got to prove that you have those four elements. So is there an offer? And an offer is normally something fairly simple. I'm going to offer you employment and you agree to work for me and I'm going to pay you. And so that's going to be, uh, if you look at those elements, the offer is offer of employment, you accepting the acceptance of the employment, me paying you a wage, which is the consideration that's giving up a benefit for a detriment. So You're giving up your time. I'm giving up my money for you to work for me. And then intention to make a legal relationship. Normally, you do that by a letter of offer or an employment contract or similar. Now, it gets a little bit more, a little bit more complicated because an offer might not be an offer at all times. So, for instance, if you go to the grocery store and you're walking around in the grocery store and you see something on the shelf, you might think that that grocery shop is offering you to buy those products. They're not. Um, those products on the shelves is what's called an invitation to treat. They're saying, we are inviting you to make us an offer to buy that Campbell's soup that's on the counter. And it's when you actually take that Campbell's soup to the counter and you present it to the cashier, that's you then offering to buy. And when they roll it through, that's them accepting your offer. So there are a little bit of different laws on offers and acceptance, but the basic is that you have to have an offer and acceptance for it to create a legal relationship. And then the consideration is giving up a detriment for a benefit, which is like working for someone your time in exchange for cash. And then you have the intention to be creating that legal relationship. And so a lot of times people will go and say, well, a handshake deal isn't worth anything. And that's not true. A contract can be verbal, it can be written, it can be implied. And just because you have a verbal contract and you have a handshake doesn't mean that it's not enforceable. But what it means is that you have to prove these four elements. You have to prove that there was actually an offer, you got to prove that there was an acceptance, and you got to prove that there was an intention to create a legal relationship with consideration. And that's where verbal contracts can often fail because in law, we normally use the words vague, ambiguous, and uncertain. And vague, ambiguous, and uncertain means that the contract is vague, ambiguous, uncertain, and can't be legally binding because there was no intention to create a legal relationship because things weren't clear enough. So if you were sell property, for instance, which is a one-page document, there's a good chance that that's going to fail on grounds of it not having the key elements in terms of the sale of property because it's vague, it's ambiguous, it's uncertain. It doesn't have whether there's any caveats that are going to be removed. It doesn't show the plans of the land. It doesn't show the possibly the registration or the certificate of title. And there's certain elements that you would normally require for property for it to be binding. But those are the main elements of a contract. Now, a deed is something totally different in the sense that if you were to have a dispute with an employee, for instance, and you were to terminate their employment, and then you're concerned that they could bring an unfair dismissal claim against you, you might offer them what's called a deed of release. And a deed of release is saying, um, I'll pay an extra 2 weeks notice if you don't sue me, and then we release each other from all claims. Now, there's sometimes in those kind of situations, there's no actual benefit or detriment flowing between the parties. So another example is if you were to lend your friend $10,000 today, and then in a week from now you said to your friend, "Hey, I forgot to give you a loan agreement. Can you sign this loan agreement now?" That loan agreement's going to fail. And the reason it's going to fail is because you've already lent the money. And so because you've already lent the money, entering into the contract post the money being lent means there's no benefit or detriment occurring in that transaction, which means it's not legally enforceable because we have a legal maxim that says past consideration is effectively no consideration. And in these circumstances, you would be giving a deed, a loan deed instead of a loan agreement. Just to make this a little bit clearer, um, so if I lend you the money today, and then in a week from now, I say, hey, can you sign off on this loan agreement? Because I've already given you the money, the borrower, there's no benefit for them to sign off on a loan contract saying that they promise to pay the money back and promise to give you interest. And if they're in default, then you can claim penalty interest and things like that. The reason is because you've already given the money. So it has to be a deed, and a deed is an offer, an acceptance, and a meeting of the minds, but there's no actual consideration. And when signing a deed, it's signed differently. So for instance, a contract is just executed by the parties, but a deed has to be signed, sealed, and delivered. And so this is you normally would use a deed in circumstances where there's a question of whether there's actually a benefit or detriment flowing between the parties. So the money's already been lent, or possibly another example is an IP assignment deed. You've already assigned the IP to one of your entities. Then you want to go backwards and record something going backwards. So you're post dating the contract itself post dates the actual event. That's when you're doing a deed. And a deed, you sign, seal, and delivered, which means that normally everybody's signature needs to be witnessed if it's individuals. And sealed means it has to be expressed as a deed. So you need the word signed, sealed. And delivered means it's not binding until it's legally exchanged. So both parties have been received the actual copy of it. The other kind of contracts is implied. So an expressed contract is one that's normally in writing. You've signed it, you've exchanged it, but implied can be circumstances where you've actually never signed off on a document at all. And an example would be where you give an employee an employment contract, they've had the opportunity to review it, they haven't actually signed it, but they've started working for you and they've been working for you for a few months. And then all of a sudden something happens and they say, oh, well, I never signed that contract, so it's not binding on me. That's not necessarily the case. Normally, a contract will be implied if it's not rejected. So you see this quite often in recruitment. A recruiter will send you an email and they'll say, we have uh, we have a bunch of really good candidates. Do you confirm for us to send you those candidates? And here's a copy of our terms and conditions attached to this email. They're not asking you to sign the contract. They're just asking you whether you agree to accept candidates from them. And in those circumstances, if you say yes, you're normally implicitly accepting their contract terms, even though you haven't actually signed anything. Another example is a click wrap agreement and a browse wrap agreement. So if you go to a website and it says click here to accept, that is the, so when you go to someone's website, you go through the shopping cart, for instance, they're offering you to buy something, you put it into your cart, and then you go to click to accept, you're accepting, and then they're also accepting. That's legally binding. But a browse wrap agreement is where there's terms and conditions on a website, and you don't actually have to click anything. It's just they're in the bottom right-hand corner of the website potentially. Now in Australia, a browse wrap agreement might not be legally binding unless it has been brought to the person's intention or attention and they know of its existence. So again, an example of this would be you get a one-page document. It says these are the key terms. This is the commencement date. This is the delivery date. This is the price of the goods, or this is the price of the services. Please sign here. And just above the signature, it says, by signing this one page, you're agreeing to our terms and conditions found on our website, found at yada, yada, yada. Um, and by signing this one page, you're agreeing to those terms that are found elsewhere. And that is similar to a browser app agreement. They're bringing your attention to the fact that there are separate terms and you have the opportunity to know of their existence. And if you sign this one pager, agreeing to the main one page, and you've been referred to these terms and conditions, then you're going to be bound by those terms and conditions. Now, if we look at employment contract, so again, it's very similar as what I just mentioned. We have full-time employment, part-time, casual, and in these kind of contracts, you normally spell out the different kinds of terms. So the commencement date, the completion date, or if it's a part-time or fixed-term contract, and then you have confidentiality clauses, intellectual property clauses, possibly dispute resolution, a clause that says that you need to comply with the employer's policies and procedures. And what's interesting about an employment contract is generally once you sign it, and same thing with any contract, once you sign it, you normally can't vary it unless the other side agrees. So a lot of times people will put into their employment contract their, um, for instance, their work from home policy. So in the back page of the contract, it says you get to work from home 5 days a week. Now, in the future, you might want that employee to come back and work in the office. Now, if your employment contract says that they work remotely, then you can't change their employment contract because that employment contract is fixed. So if you now want them to come into the office, you have to get them to consent, and they don't need to actually consent to it. So in these kind of situations, you never say in an employment contract that person's going to work from home remotely. You're going to say in the employment contract, you're going to work from the office of the employer from time to time in accordance with its policies and procedures. And then you have a clause that says the policies and procedures don't form part of this employment contract. And what that means is that you can change your policies and procedures without actually changing the employment contract. So, for instance, you might have a work from home policy that says employees can work 2 days from home, 3 days in the office. And then later on, you want all your staff to come in 5 days a week. Then you just change your policy without affecting the employment contract at all. So anything that's likely to vary or change over time, like dispute resolution processes, bonuses, incentive structures, things like that, you don't actually want as part of the employment contract because you cannot change it. You want it as a policy, and once it's a company policy, then it can be reasonably changed by prior notice. Now, if you look at property generally, there are various clauses, and without these kind of clauses, it's not going to be legally binding. It's going to be vague, ambiguous, uncertain. Property also has to be in writing. So we have under legislation that if it's a transaction dealing with property, a verbal agreement and implied agreement's not going to fly. It has to be in writing. And so in a lease arrangement, the first one is it a lease, is it a sublease, or is it a license? And it's quite often that someone will go and say, okay, well, I've signed off on a lease, but I want my mate to come and basically rent a desk off of me for a short period of time. And they might give them a sublease. That's probably not an actual sublease because if it's a sublease, you have to get consent from the landlord under the lease agreement. And normally, a sublease can be registered against the land, just like a lease. And on top of that, um, the sublessor can actually deal directly with the landlord and skip you completely. So if you're ever going to be doing hot desking or anything similar within your office, and you're going to have someone come in and rent a desk off of you, you want to make sure it's a license and not a lease. Because if it's a license, like a co-working space, they don't have property rights in relation to the land. They just have a contractual right to use that property during the fixed term, and you can remove them. But again, you want to have very clear terms. So, what are your obligations? What are their obligations? What's the duration? Who's paying the outgoings? Who's paying the land tax? Who's paying the insurance? Are you going to be making it good once let's say you do a commercial fit out? Who has to put it back to how it was? So these kind of things go into the uh, lease agreement to make sure it's not vague, ambiguous, and uncertain. Because if it doesn't have all these things, then it can be a circumstance where the court says, well, it's vague, ambiguous, uncertain, unenforceable, and I'm going to cross out the entire contract. So there's certain regulated areas that need to have these elements within the industry to make sure that it covers all the essentials. So for an employment contract, that would be an offer and acceptance, but it's going to be the position title, the salary, um, the statutory entitlements, normally a termination clause. But then the Fair Work Act also has a lot of that built into it. So it really does depend what industry you're in and what you're dealing with to determine whether a contract's going to have all the essential clauses. Now, when we look at a service agreement, this is what most people make a mistake on. They say, this is what I'm going to do, but it doesn't say the person receiving the service has to do anything. And it also doesn't say what you're not going to do. And that's where we normally have a dispute because it's a lack of communication, a lack of clarity in a contract that causes people end up going to court. That's why we normally go to court because the communication or clarity of the actual document itself. So if you're providing a service, you want to say, these are the services that are included. These are the services that are not included. And if I'm going to provide you with services, then you have an obligation back to me to give me approval within a reasonable period of time, to give me the documents that I need within a reasonable time period of time, to seek any amendments early so that I'm not stuck making changes at the end, things like that. So you want to make sure whenever you're providing a service or goods that the other person also has obligations as well. So for instance, if you're selling goods, you'll say, we'll deliver you to your address. But if you're not present and there's a redelivery fee, you're liable for the redelivery fee. Or if you're not, if you gave the wrong address, then you've got to pay for the redelivery fee. Or if we're delivering goods to you and it's defective, then you have terms and conditions dealing with warranties. Like if you want to claim against the warranty, then how do you claim against a warranty? You have to have a step-by-step guide. You will contact us and send us an email. You will attach the photographs. You will explain what the defect is. You'll do it within 7 or 30 days from receiving the goods. And if you don't, then our warranty period doesn't apply. So everything needs to be very specific so that everybody's on the same page and the meeting of the minds element is reached when you're having a contract. So services agreement, whether it's a services agreement or professional services or any of these on the others around here on the other side of the slide, everything has to be very clear. How are you accepting it? How are you offering it? What is the price? And how do you terminate? What's amazing is that a lot of contracts we see have no termination clause at all. Or if they do, they could be unlawful as well because there could be a fixed term contract. So the ACCC have been prosecuting people for having fixed term contracts and automatic renewal clauses that basically try to bind a consumer for an entire fixed term. So let's say we have a software as a service agreement. It says you're going to pay an annual fee. That annual fee for the subscription is $1,000 and either party can terminate on 30 days notice, but you're liable for the entire initial term, the entire 1 year, even if you terminate. Now, the question then becomes, is that a penalty? Because if you are requiring somebody to pay the entire year of service, but they're only using 2 years or 2 months of service, and they terminate on 30 days notice, as the contract says, you're effectively charging them for 10 months of service that they're not receiving. And it's been found that that can be a penalty. And in Australia, a penalty clause is not legally binding. And the only way for a fixed term contract to generally be binding is if you can prove that charging them that remaining 10 months is not a penalty, but rather it's a pre-genuine estimate of your loss. So for instance, if you say it's a 1 year contract, you can terminate whenever, but you have to pay the entire 1 year and they terminate at the 2 months. Well, you've got to prove that charging them those extra 10 months is a legitimate business expectation. And, I think in 2009 or so, Fitness First got sued and went to court for this. And they found that even though they sign up 1 year memberships, that is, there's a legitimate interest for Fitness First to know how many members they have because they rely upon that for business decision making purposes. So for instance, they look at how many members they have to make a determination of how many personal trainers they hire, how much more equipment do they buy, do they open up another location close by? And so there's a business legitimacy to lock someone in for a 1 year contract because your entire business is based on a subscription base and you make your decisions on people being locked into these contracts. And so in that case, Fitness First was successful, but you have to be careful if you have fixed locked contracts with no right of refund, um, and also automatic renewal clauses where it just says we're signing a 1 year contract, it's automatically going to renew for another year and successive years over and over and over again. Again, that can be found to be an unfair contract term. And generally speaking, if you do have an automatic renewal clause, you want to make sure that you give notice to the consumer that it's going to renew and that they have an opportunity to cancel before it renews and they're aware of that clause existing. Otherwise, there's grounds for that clause to be not legally binding. Now, if we look at negotiating contracts, a lot of times as a solicitor, we'll say we need to get 10 things into this contract, or we want 10 things in this contract, but we really only need six. If we can get them to agree to these six, then we've just done a really great job on our contract. So it might be we don't really care about the solicitation clause with them poaching our clients because we know they can't do it because our clients have really good relationship with us, but we want to get the best price we can. So what we'll do is we'll put a very high price and we'll put the solicitation clause in, and then we'll try to get them to negotiate it out. Um, and then they try to negotiate on price. And we say, okay, well, great, we'll agree to the non-solicitation clause coming out, but we're not going to agree on the price. So you want to use that as leverage. So normally you take 10, you negotiate six, and by giving up four, then you're still going to get a fairly good outcome in your contract. Some things to look at. How long do you want to have your contract for? Is there a reason why you're locking in your customer for a period of time? Is that good for business? Or is that actually scaring people away? So a lot of times if you have people expect to be able to terminate whenever they want if they don't like the service or if they don't like the goods or the product or the SaaS or the whatever it is. So why are you actually locking them in? And if you are locking them in for a duration of time, what's the process to terminate? And if they do terminate, can you charge them the entire amount? And if so, why? How are you going to explain to a court they're not getting a refund for terminating early? And so normally we have termination for convenience. Either party can terminate on 30 days notice after an initial 6 month period. And then people say, well, why 6 months? Well, normally that's the onboarding process. If it's software, that might be the beginning process of building a campaign if it's marketing. So there's a lot of expenses going into onboarding the client for the 6 months. So you say, you have a minimum term of 6 months because that's the most expensive part of our engagement. And then after that, we have more profit as we move forward. So you have to do 6 months. And you can explain to the court, the first 6 months is when we're doing all the onboarding. So that's why they're locked in for that period of time. You also want to have a clause that's termination for breach. If someone goes insolvent, if someone's not paying their bills, if someone disappears, if someone's not giving you the instructions that you require or the documents and you're going to miss all the due dates. So there's clauses like that that you really need to consider. And what are the process for renewal? So is it going to be on the exact same terms? Is it going to be on different terms? Is the price going to change? Is the notice period going to change when you renew into another clause or into another year? So things like this that you really need to consider, and you got to, when you read a contract, look at that contract, consider what portions you can give up and which portions you really need, and make sure you know that going into a negotiation. Now, we touched upon this already, but just because you're the one that's providing the service doesn't mean that you're the one that have the obligations only. If you're a software developer, you need instructions, you need approvals, you might need them to do their user acceptance testing, you might need a payment. So you got to put obligations on both sides. And what do they mean? If you just simply say you got to give me documents, that doesn't mean anything because when are they actually in breach? Even if you say you got to give documents within a reasonable period of time, what does reasonable period of time mean? To them, it might mean 3 weeks. To you, it might be 5 days. You're better off saying, if we request instructions or documents, you must give it to us within a reasonable period of time, but no later than 5 days. So it's very clear on exactly what the obligation is, when it becomes a breach, and how can you get out of the contract once there is a breach. So you've got to think about the hypotheticals when you're going through your contract of what is the obligation? Is there anything else I need? How do they breach it? Is it clear how a breach occurs? And how do I get out of it once there is a breach? Now, the last thing really is looking at, is your business protected? So there is something called the New York Convention for the Foreign Recognition and Enforcement of Arbitration Awards 1958. The short form is the New York Convention. You can Google it. Effectively, it says that anyone that's in a commercial contract can agree to exclude courts from their contract. So, for instance, if you were selling a service here in Australia and you had a client in New York and you were had a contract that says that Melbourne is the location to resolve the dispute, and the courts of Victoria is the jurisdiction for bringing a claim, and the governing law is Victoria as well. Then in those circumstances, you provide the services, you issue the invoice, they don't pay you. Well, what do? You've got to sue them now in Melbourne. You think this is great because we were able to negotiate Melbourne as the location. We're able to negotiate Victoria as the applicable law, and they might not even show up. So you're getting excited that you're just going to go get judgment, and you go to court. They don't show up. You get judgment against them, and now you have an Australian judgment that is not worth anything because they don't have any assets in Australia, and the courts of Australia can't go beyond Australia. So now you've just paid all this money for a lawyer to get a judgment for you in the Supreme Court of Victoria, and it's not worth anything because you can't enforce it. And so, and between Australia and the United States, we don't have a mutual recognition of judgments like Australia and New Zealand do, where we get a judgment here, we can enforce it in New Zealand. But if you get a judgment here, you can't enforce it in the United States. So a lot of times when you're doing international business, you will insert what's called an arbitration clause. And an arbitration clause is saying we can't go to court unless it's urgent and we got to freeze bank accounts, for instance, or get an injunction. But we can't go to court. The parties agree that an arbitrator is going to be the one that makes the final decision. And an arbitrator is normally a judge or a lawyer or barrister, and they have normally taken courses to become an arbitrator, and they are the ones that make a final determination. And under the New York Convention, if you have an arbitration clause, and let's say it's under Victorian laws and the arbitration does happen in Melbourne, and you go and you bring an arbitration application, and then you get a decision from an arbitrator, that's called an arbitral award. And an arbitral award under the New York Convention is recognized in 153 countries or 151 countries around the world as good as a judgment. You can now walk into the courts of New York. You can say, I have an arbitration decision from Australia. Can you please stamp this as if it's a judgment from New York? And they'll say yes, they'll stamp it, and then you can go enforce it just like it was a New York judgment against the assets of the person that you were providing services to in New York. So consider whether you want to have an arbitration clause in your contract. And a lot oftentimes if you're doing business online, you'll see with Microsoft or PayPal or Stripe or any of these, most of them have arbitration clauses in their terms and conditions because they're offering services worldwide. And it says for PayPal, for instance, if you have a dispute, you got to do arbitration in San Diego because that's where their headquarters is, or if it's Microsoft at Seattle, for instance. So you want to have a look and consider whether you want an arbitration award, because if you're the one that's providing the goods or you're the one that's providing the services, you want to be able to sue them. Whereas if you're the one receiving the services or receiving the goods, you might not care as much because it's probably you that's going to be sued for not paying as opposed to you being the service provider itself. So have a look at that, Google New York Convention, and see whether that's something that you need. The other thing to consider is a non-solicitation clause. Do you want that where they can't steal your employees? They can't steal your clients? Do you want an intellectual property clause? Do you want a confidentiality agreement? Do you want a restraint of trade, preventing them from offering competitive business to your customers? Do you want something to deal with your trademark? So if you look at a franchise agreement, there's a license of a trademark normally to the franchisees because they're using the trademark Subway. But if you terminate the franchise agreement, you want to be able to terminate the license agreement so that that company can no longer use Subway restaurant trademark anymore because it was just a license to use that trademark. So if you're going to be doing business with someone and they're going to be using your trademark, you want to consider whether you get a trademark. And what happens on the termination of the contract, does the license to use that trademark also end with the termination of the contract? And that's why you'll see complex contracts that say, this is the termination clause, and this is what happens upon the termination. And so you want to think about what happens on termination. If you're manufacturing goods and they have all these goods in their possession, can they still sell them? If you're providing a service and they terminate the service, does the IP actually transfer once it comes into creation, or does the IP actually transfer once you've been paid your invoice? And only once you've been paid all the money that you're owed under the contract does your intellectual property transfer. So things like that is normally what lawyers are dealing with, and we're dealing with the hypotheticals. So we talked about negotiation briefly, but we also have the BATNA, which is the best alternative to a negotiated agreement. So you look at what are the things that you need, what things don't you need, you prioritize the top ones, you compromise on the ones that you don't really need, you come up with alternative suggestions, and you communicate what is the most important aspect, and that's how you come to a negotiated settlement. Now, the biggest disputes that we have are people hiring us to draft a contract, and then they start the business already and never get around to actually signing it. So they say, oh, well, we're going into partnership with our colleagues. We're going to go and we need a shareholders agreement drafted. So we draft the shareholders agreement, we send it over to them, and then someone dies or they just never sign it. And they've never actually passed it around, and it's full of track changes. Well, if it's full of track changes, when you make an offer saying, here's the contract, and someone comes back with track changes in it, that's a rejection of your offer. So if you give them the contract, say, here's my offer in this contract, and then they come back with track changes back, that's a counter offer. That's saying, we don't accept your offer. We are making a counter offer on these terms. Do you accept that? So the minute you make any amendments to a contract you receive, you're making a counter offer. And once you make a counter offer, the original offer is automatically terminated, withdrawn, and it might not be able to come back. So that's also, you got to be careful of when you're negotiating. Someone says, I'll pay you $100,000 to settle this. You say, oh, I think I can get more out of them. How about 110? They say no. You can't go and say, oh, okay, well, give me the 100 then. They said, no, it's off the table. We gave you our best offer. You rejected it by making the counter offer. And that's the same thing goes in contracts as well. So the biggest problem we have is people making amendments and then signing it, or people never actually signing it, or people not signing it correctly. So if you're a company, you should be signing it off. If you have one director, the director needs to be signing. If you have two directors, it should be both directors. If you have two directors and a secretary, or one director and a secretary. It should be the director and the secretary. Um, and that's really important because a lot of times people don't even put the right entity on the contracts. It might be Bob's Builders, and they know him as Bob Builders, and they put that on the contract, but there is actually no such thing as Bob's Builders. It might be Bob who works at a building company called Macintosh, um, but it doesn't actually make any sense that you have not bound the legal entity or the individual to the contract itself. So you can go to ASIC Connect, so ASIC Connect, you can just Google it. Someone gives you their company name. You can go, you can do a search. You can get their ACN number, the Australian company number. It's always safe just to put that next to the company name so that you know that it actually exists. You've done your due diligence to make sure you're binding a company and the company's properly signing. If someone's operating as an ABN, you want to go to ABN lookup. You can Google that as well. And you want to get the trading name plus, or the business name plus the ABN next to it to make sure that you're locking in the right entity or the right person to that contract, because it's more often than not, if you just not putting the PTY Ltd into the contract, not putting the right company name, it's going to be very difficult for it to actually be legally binding on the parties. And then we already touched about this. And then the last one is just e-signatures. Since post-COVID, most places is now legally binding. So a company is allowed to sign off on a contract electronically by two directors if it has two directors, or one director if it has one director. Um, in Australia, in New South Wales, Victoria for sure, and I think Queensland as well, and ACT and most other states, they now accept electronic signing on behalf of individuals as well. But deeds are different, and every state it has a different law on deeds because deeds have to be witnessed. So if an individual signing, it has to be witnessed by somebody in their presence, and that's in most states. So you just got to make sure that if you are going to do electronic signing by individuals, then you want to see whether a witness also needs to be witnessing that individual signature. And more times, more often than not, if it's a deed, you will need that witness, and they're going to need to be in their presence. So you can't just say send a DocuSign out. If you're going to send a DocuSign out, you're also going to have to send a Zoom link as well, so that people are in their presence virtually, witnessing each other's signature being applied to the DocuSign document. And then we've already touched upon browser apps. So that's all we have at the moment. We're going to jump into the questions. I'm going to pass it over to Joel, and then I'll be back in about 5 minutes. Thank you very much.
Thank you so much, Damon. Really appreciate the information. Guys, how's everyone doing? I know there's a lot of information, and most of you guys are probably eating lunch at this point in time, so it's a lot of micromanaging and splitting your attention. But fear not. I will have every one of the webinar episodes, both post and present, available on our YouTube channel. If you just type in Lawpath on YouTube, it will be available there. And the slides that you are witnessing today will also be in the email that I send out as well. I'll just attach the whole PDF for those who haven't been a part of it before. Now, guys, please flood those questions in. I know there's probably a lot of information rattling around your brains right now, so if you just feel like you can't nut it out, go ahead and put it out there, and we will have Damon answer those for you after this little presentation. And also, go ahead and please thank Damon as well, because he's a very busy man and he's actually taking an hour out of his day to do this for you guys. Now, what kind of information you're getting, which would usually cost the hundreds of thousands from a lawyer to be giving you. So you're getting this all for free. So yeah, please, by all means, thank Damon afterwards. Now, what can we provide you over here at Lawpath? If this information that we're conveying to you here is super helpful and we're putting it in a way that you find extremely helpful, but you may need more information, or there's other things that you can see will arise later on, the legal advice plan is perfect. With the legal advice plan, you're essentially going to be getting the same information that Damon's conveying you today, but it's going to be more specialized and specific to your business. If you're expanding your business, if you created a company for the first time, if you're taking on employees for the first time, if you're expanding out of state, whatever it may be relating to your business, we can help with the legal advice plan. You get unlimited 30-minute calls every day, whenever you want, with the same lawyer of your choice. And you also get access to our entire document library. Now, this is based around law, but I also mentioned the other ones. We've got accounting and tax as well. Now, if you're used to having all of your accounts on what's the word I'm looking for? Windows, like Excel spreadsheet, for example. If you've ever gone to speak to an accountant or a tax agent, they'll go, "Oh crap. Okay, I need to quantify all this. Yeah, I'm going to need a little bit of time," and maybe they'll charge you a little bit more. Having us assist you with your accounts, that's all your bookkeeping, your payroll, employees for the first time, investing in new things, company work, vehicle, maybe you're taking on a new workspace, whatever it may be. This is money that you need to be calculating, invoices, etc., because it all comes back on tax. Now, not only can we assist you in making sure all your books are very neat and clean, so the tax man's not going to be knocking on your door and you're going to suffer any unwanted fines, but naturally, we can also help you reduce the amount of tax you're paying through looking at what you're planning on investing and usually paying and help you make those reductions. Currently, at this point in time, the legal advice plan is, as you can see there, 1,668. Now, last week on I can't remember what day, we brought out a email that I hope all you guys got, which was helping you identify the discounts that we have available at the moment for April. Unfortunately, I know it sounds very gimmicky, guys, but unfortunately, today is, hand to God, today is the last day that we have discounts for any of our plans. Really big plans. We have bundles, so you can get the legal accounting and tax for 50% off. It's huge. But if you can, you'll probably see it in the slideshow if Damon wants to flick it through. But we currently have the legal advice plan retailed for you guys at with 40% off. So from 1668 it comes down to 1,288. So if you wanted to get that legal advice, 1,288 is the best time and the best price at where you're probably going to get for a long time, at least until June. So definitely something to consider. Go ahead and hop on our platform and you can see some more of our offers. Definitely check out that 50% off if you want to start your business off right, or if you want to transition from old lawyers and accountants into something a bit more streamlined like Lawpath, where you can have those consistent calls every day. Everything's automated. We've got AI. You're not having to go into an actual room to speak to someone and drive all the way out to their office. You can just click of a button, same day consultation. If you are interested in that, please go ahead and check that out. And yes, that should be everything from me. Again, I will be sending an email out to everyone with all the information. If you have any interest in any of our plans, but you just want a further consultation with me, I'm happy to give you a call afterwards and we can go through it a bit more in detail and see where your business is at and how we might be able to help.